My name is Jason Strickland, and I'm an attorney with Warden Smith and head of our construction law practice group. I will be speaking about recent changes to North Carolina's mechanics lien and public bond statute. Over the past year, significant changes have been made to these statutes which impact a contractor or subcontractor's right to assert a lien or a bond claim, two very important rights on private and public construction projects in North Carolina. Under the old system, a general contractor, that is a contractor that dealt directly with an owner, or a subcontractor, that is a contractor that dealt with the general contractor or another subcontractor, had the right to assert liens on either the project property, that is the land upon which the project was constructed, or project funds. The process previously for asserting these liens was relatively straightforward. A general contractor that dealt directly with the owner could perform its work without having to worry significantly about its or its subcontractor's lien rights. At the end of the project, if the general contractor had not been paid as required by its contract with the owner, could assert what was known as a claim of lien on real property. This required that the general contractor file a document with the clerk of superior court in the county where the project was located, a document titled Claim of Lien on Real Property. This document had to be filed within 120 days of the last furnishing of labor or material by the general contractor to the project. A subcontractor that dealt with the general contractor or another upper tier subcontractor could provide a document to the owner, the general contractor, and any upper tier subcontractors that asserted a lien upon funds. This document was titled Notice of Claim of Lien Upon Funds. This document could be served at any time, but only caused a lien to be asserted to funds actually owed. Thus, if the subcontractor waited too long to serve the notice of claim of lien upon funds, there might not be funds actually owed downward to which the lien upon funds could attach. The subcontractor who asserted a lien upon funds timely, such that there were funds owed to which the lien upon funds could attach, could also, through what is known as subrogation, assert the general contractor's lien upon real property. One of the significant features of the lien upon real property that could be asserted, again, by either the general contractor or a subcontractor through subrogation was what is known as the doctrine of relation back. The lien upon real property is a secured interest in land, like a deed of trust provided by a homeowner to a bank when the homeowner takes out a mortgage loan. Secured interests have what is known as priority, such that competing secured interests do not share in a recovery pro rata, but rather whichever secured interest has priority will recover first before any subordinate lien or secured interest can recover. Under North Carolina's mechanics lien statute, claim of lien on real property, unlike a deed of trust, had priority not from the date of its filing, which typically would be after the end of the project, but rather had priority from the date of first furnishing by the general contractor asserting the lien on real property. Thus, the general contractor effectively had a lien with a priority dating from a time well before any document asserting that lien was actually filed. This allowed for what was sometimes referred to as a silent lien. That is a lien that existed but had no document representing or asserting it on file or in the possession of anyone. The existence of this silent lien and the problems that it posed for title searchers attempting to determine whether there were secured interest in land was the primary driving force that led to the changes to the mechanics lien law I will be discussing today. The most significant change to North Carolina's mechanics lien law is the creation of a new player in the lien process. This new player is the lien agent. The lien agent is effectively title insurance companies which have volunteered to serve as lien agents for construction projects. The lien agent acts effectively as a clearinghouse for lien claims. No later than the time an owner first contracts with a general contractor, or no later than the issuance of a building permit, the owner is required to designate a lien agent. This basically involves the lien agent picking from the available title insurance companies and providing a fee to the title insurance company to act as the lien agent. The general contractor and any subcontractor which wants to preserve its ability to assert the general contractor's lien rights is required to provide a notice to lien agent to the lien agent. This can be accomplished through a document titled simply Notice to Lien Agent. The notice to lien agent should identify the general contractor, the owner of the property, should identify the property being improved, and include a general statement that the general contractor or subcontractor is reserving all of its rights to assert a claim of lien on real property. The effect of the notice to lien agent is not to actually create the lien, but to provide notice for title searching purposes that a lien could be asserted, and that if asserted, that lien might relate back to the first date of furnishing by the general contractor. If the general contractor or subcontractor provides the notice to lien agent within 15 days of its first furnishing of labor or materials to the project, then the general contractor's lien, as before these changes, will have the ability to relate back to its first date of furnishing. If the general contractor or subcontractor provides its notice to lien agent more than 15 days after its first furnishing of labor or materials to the project, then its lien can relate back to no earlier than when that notice to lien agent was actually provided. If the general contractor never provides a notice to lien agent, then the general contractor can still have a lien on real property. However, that lien on real property will not relate back, but rather will have priority only from the date upon which the claim of lien on real property was filed with the Clerk of Superior Court. The requirement that the general contractor file the claim of lien on real property with the Clerk of Superior Court for the county where the project is located within 120 days of last furnishing is unchanged. Similarly, the requirement that the general contractor file a lawsuit to enforce the lien on real property within 180 days of last furnishing is also unchanged. There is also a new requirement that in addition to filing the claim of lien on real property with the Clerk of Superior Court, the claim of lien on real property also be served through some mechanism that provides delivery receipt or confirmation of delivery receipt upon both the owner and any general contractor or upper tier subcontractors in the case that the claim of lien on real property is asserted by subrogation. Thus, there are new requirements and new responsibilities for general contractors and subcontractors at the start of the project, which are in addition to the previously existing requirements of serving the claim of lien on real property at the end of the project. No longer can a general contractor or subcontractor simply perform its work and rely on the fact that it can assert a lien at the end of the project only if necessary. Although the general contractor and subcontractor can still assert a claim of lien on real property at the end of the project, if the general contractor or subcontractor has failed to provide a notice to the lien agent at the start of the project, the general contractor or subcontractor will be unable to relate its lien back to the first date of furnishing. Competing secured interests frequently arise during the course of a construction project. Thus, the ability to relate a lien on real property back to the first date of furnishing is frequently and commonly the most important part of the lien right. Thus, if the general contractor or subcontractor is unable to relate its lien back to its first date of furnishing, the lien may be of little or no value to the general or subcontractor. The actual process for a subcontractor to assert a lien upon funds is mostly unchanged. However, if the subcontractor wishes to assert the general contractor's lien on real property through subrogation, then the subcontractor will have to follow the same steps as the general contractor would to assert the claim of lien on real property, in addition to and after asserting the subcontractor's lien upon funds. This includes providing at the outset of the project a notice to the lien agent to preserve the ability of the subcontractor to relate its lien back to its first date of furnishing. An important consideration for general contractors and subcontractors providing notices to lien agent, and for owners designating lien agents, is the liensnc.com website. The liensnc.com website can be found at liensnc.com. The liensnc.com website allows owners designating lien agents and general contractors and subcontractors providing notices to the designated lien agent a website where this can be accomplished electronically without the need for the preparation of paper versions of those designations and notices. An owner, general contractor, or subcontractor using the liensnc.com website will be required to register and obtain an account for no fee with the website. Once an account is established, the general contractor, owner, or subcontractor can use that account for all projects in which a lien agent would need to be designated or a notice provided to the lien agent. The liensnc.com website provides prompts such that the owner, general contractor, or subcontractor will know which information needs to be required or provided in order to designate the lien agent or provide a notice to lien agent to the lien agent. The liensnc.com website also allows for searching of designations of lien agents and notices to lien agents. This automates the process for which these changes were primarily implemented. That is, to allow for someone to search records relating to real property to determine if there was a secured interest or the potential for a secured interest to exist, and to eliminate or mitigate the existence of the silent liens. The statute governing the mechanics lien law allows for paper copies of the designation of lien agent or the notice to lien agent to be provided. Thus, the availability of the liensandc.com website does not bar these notices from being provided by paper through the mail. However, the liensandc.com website does require or allow a more efficient way of performing these tasks electronically without the need to create paper forms or to send them through the mail. Changes have also been made to North Carolina's public bond statute, commonly known as the Little Miller Act. The Little Miller Act is so called because it's patterned after its federal counterpart, the Miller Act. North Carolina's Little Miller Act applies to projects which have a public owner. That is, projects where the owner is the state of North Carolina or one of its subdivisions, or a local government, such as a county, city, or a municipality. North Carolina's lien law does not apply to projects where the owner is a public owner. This is primarily because the General Assembly does not want liens asserted against property owned by the state. The Little Miller Act calls for the right to assert a lien that would exist on private projects to be replaced by a right to assert a claim against the payment bond. A payment bond is obtained by the general contractor on the project from a surety which acts similar but differently than an insurance company. If a subcontractor establishes that a general contractor owes it money, the general contractor is unable to pay the money owed, then the subcontractor may have its recovery against the payment bond, effectively requiring the surety that issued the bond to make the payment. The surety would then have the ability or responsibility of attempting to make itself whole by recovering against the general contractor. An important facet of North Carolina's Little Miller Act is that recovery against the payment bond can be obtained not only by first-tier subcontractors that dealt directly with the general contractor, but also by second-tier, third-tier, and more remote subcontractors who supply material to the project, even though they did not deal directly with the general contractor. Another important facet of the Little Miller Act is that a second-tier, third-tier, or more remote subcontractor can also have a recovery against the payment bond, even though that subcontractor does not deal directly with the general contractor. This recovery can be had so long as the second-tier or more remote subcontractor provides a notice to the general contractor of the amount the subcontractor claims it is owing within 120 days of the subcontractor's last furnishing of labor and material to the project. The fact that the general contractor may have already paid the first-tier subcontractor for the labor and material in question does not provide a defense to the general contractor in regard to the second-tier or more remote subcontractor's claim, so long as the second-tier or more remote subcontractor provides its notice to the general contractor within 120 days of last furnishing. This has created what is known as the double payment problem. The double payment problem exists where a general contractor pays a first-tier subcontractor for work or material provided to the project, and the first-tier subcontractor then fails to pay its second-tier subcontractor for the same labor and materials. If the first-tier subcontractor then absconds with the money or becomes insolvent, the second-tier subcontractor so long as it provides its notice to the general contractor within 120 days of last furnishing, would have a claim against the payment bond, which is effectively a claim against the general contractor. And the general contractor ultimately will be required to pay for the same work twice. That is, having to pay double for the same work or material. This circumstance was the primary driving force behind the recent changes to North Carolina's Little Miller Act. The major changes to the Little Miller Act involve, first of all, the contractor providing to its first-tier subcontractors a contractor's project statement. The contractor's project statement includes the name of the project, the physical address of the project, the name of the owner of the land upon which the project is being constructed, the name of the contractor, that is the general contractor providing the contractor's project statement, the name, phone number, and mailing address of the contractor's registered agent, and the name and address of the principal place of the entity providing the performance bond and payment bond. That is, the surety that is providing the payment bond for the project. The Little Miller Act also requires that first-tier subcontractors provide the contractor's project statement to their second-tier subcontractors, and so forth down the contracting chain. A party which is contracted to provide labor and materials to the project, but that does not receive the contractor's project statement, is entitled to suspend or delay its performance obligations on the project. In other words, a second-tier or more remote subcontractor, which is contracted to provide labor and materials, may refuse to do so without penalty if the first-tier subcontractor has failed or refused to provide the contractor's project statement to that second-tier or remote subcontractor. This is also true of the first-tier subcontractor, such that if the general contractor fails or refuses to provide the contractor's project statement to the first-tier subcontractor, the first-tier subcontractor, without penalty, can delay or suspend its performance obligations under the contract and on the project. The other major significant change is that all subcontractors at the second tier or below are required to provide a notice of public subcontract to the general contractor. The contents of the notice of public subcontract include the name and address of the subcontractor providing the notice, a general description of the land upon which the project is being constructed, a general description of the subcontractor's contract, a general description of the labor and material to be furnished by the subcontractor. The purpose of the contractor's project statement and the furnishing of the subcontractor's notice of public subcontract is to provide notice to the general contractor of those second tier and more remote subcontractors that the general contractor's first tier subcontractor is dealing with. This is intended to allow the general contractor to manage its payments to the first tier subcontractor in a way that eliminates or at least minimizes the risk of double payment. For example, the general contractor, now being aware of the second tier and more remote subcontractors with whom its first tier subcontractor dealt, can require lien waivers from not only the first tier subcontractor, but also those second tier and more remote subcontractors before making payment to the first tier subcontractor. Similarly, the general contractor may elect in certain circumstances to make payment to the first tier and more remote subcontractors by joint check. Ideally, the general contractor, through the contractor's project statement and the notice of public subcontract, will have the information necessary to either obtain these lien waivers or to make these joint checks. The notice of public subcontract can be provided by a second tier or more remote subcontractor at any time during the project. However, whereas the second tier or more remote subcontractor's recovery against the payment bond was previously unlimited, the second tier or more remote subcontractor's recovery against the payment bond is now limited to either $20,000 or that amount of labor and materials that was furnished within 75 days prior to the furnishing of the subcontractor's project statement. Thus, if the subcontractor provides its project statement at the outset of the project, it will be in the same position it would have been prior to these changes. That is, the subcontractor may have a full recovery against the project payment bond of that amount of which it is owed. However, if the subcontractor fails to provide a notice of public subcontract at the outset of the project and waits only to the end of the project to provide the notice of public subcontract, then only that material in dollar terms above $20,000 that was furnished within 75 days of the end of the project when the notice of public subcontract was provided will be recoverable. If the subcontractor provided a substantial amount of material to the project and a substantial amount of material was provided more than 75 days before the end of the project, the subcontractor could lose the ability to recover a major portion of its claim against the project payment bond. Thus, to be fully protected, a second tier or more remote subcontractor on a public project in North Carolina should make sure to provide its notice of public subcontract to the general contractor at the very outset of the project, and in no event no later than 75 days after the second tier or more remote subcontractor first began to provide labor or materials to that project. The purpose of the contractor's project statement is to supply to second tier and remote subcontractors that information necessary to both provide the notice of public subcontract and also to pursue the bond claim at the end of the project. Second tier and more remote subcontractors, as well as first tier subcontractors who ultimately do pursue a claim against the project payment bond, must file a lawsuit to enforce their bond claim no later than 1 year after their last furnishing of labor or material to the project, or 1 year after final settlement between the general contractor and owner of the project, whichever is later. This requirement is in addition to the requirement that second tier and more remote subcontractors provide their notice of public subcontract and also provide their notice of claim against the payment bond within 120 days of last furnishing. It should be noted that the requirement for a notice of public subcontract does not eliminate or satisfy the need for the second tier or more remote subcontractor to provide a notice of claim against the payment bond within 120 days of last furnishing. Should you have additional questions about the changes to North Carolina's mechanics lien law or public bond law, or any other construction-related questions, please feel free to contact us. My contact information can be found at Ward and Smith's website, which is wardandsmith.com, WARDANDSMITH.com. Thank you.